Today I want to cover some information on disclosures when it comes to probate transactions. And I'm not going to go through the list of disclosures and which ones are required. What I want to cover with you today is the disclosing material facts and how kind of that process can tie into a transaction and maybe make things go wrong. So if you want detail on which disclosures and that sort of thing, come to one of my live probate classes. You can reach out to me via email or call me because I do have that information as well. But I want to cover a couple of specific instances here today. So one is it was a court confirmation sale. And in California, that's a court supervised sale where they confirm the buyer in court. So it's a court confirmation sale. The seller, the administrator of the estate, knew that there was REAP, which is a City of LA lien on the property. The attorney had been informed the day before the sale. So both parties knew there was REAP on the property. They failed to disclose that. They did not provide a preliminary title report, or in the state you're in, they may call it a title commitment, showing this information. So the buyer did not have any disclosure. But the thing is, it was a material fact that was known to both the attorney and the estate administrator. It should have been disclosed, no matter what. But it wasn't disclosed. They confirmed this buyer. After the fact, he finds out he can't close because this lien is there, finds out there's a problem. So one note to everybody, make sure that you reach out to me or some other closing agent and get a preliminary title report. If you're in a different state, it's called title commitment. You want to get that before you're going for any court matters because you need to know what's affecting that property before you're in court making final decisions and getting court orders, number one. Number two is if you are on the seller side or if you're working with the attorney, you got to disclose material facts. In most places, definitely in California, but I'm sure it's similar in a lot of other states depending on the disclosure rules, we have to disclose here in California any material facts that we know. As a real estate agent, you have to disclose. Now, your seller may not have ever lived in the property, may not have ever even been to the property because they're the administrator, they could live out of state or something. So they may not know the issues with the property, that the plumbing doesn't work or that there's a leak in the roof. But any facts that you know as a real estate or anything that you see or something that's disclosed on a title prelim, you should disclose those things to the buyer. That way you don't end up in these sticky situations. Court confirmation sales are no contingency sales. So when you walk out with no contingency sale, now there's a big problem that was not disclosed. They have a conundrum. They have a really big problem. In that case, it ended up working out. That buyer did not want to be tied up in a legal battle, didn't want to have any problems. I think he ended up buying it and then selling it to someone, wholesaling it to someone else. It was a deal that had money in it, but it could have gone a lot worse and could have been a situation that ended up in a big legal battle. I have another transaction currently going on right now. It's in escrow, and well, almost in escrow. It's an accepted offer. Here's what's going on with this one. They accepted an offer. It's a court confirmation sale, which is a no contingency sale. Yet they accepted an offer that has contingencies. Generally speaking, if you have a no contingency sale and you have to go to court, the attorney's not going to schedule the court date till the contingencies are removed. So now, I don't know if the seller knew this going into it. Hopefully they did. If you're ever in this situation and you're a real estate agent, you can communicate this to the seller. But what they did is they put themselves where they can't accept other offers because they've already accepted this offer. Yet they can't schedule a court date till contingencies are moved. So they kind of put themselves in limbo for a period of time until the contingencies are removed. They don't usually like to do it that way. They want to get an offer that has no contingencies in it where all the due diligence has already been done. So very important to note that on court supervised sales, which are usually going to end up closing with no contingencies after the court date, you want to make sure all those contingencies are taken care of. You don't want to get yourself in between a rock and a hard place where you can't close, but you can't move forward because you got a problem. So keep that in mind. Look, if you want to increase your knowledge in probate real estate, go to the products page. There's tons of products there to help you increase your relationships with the attorneys, increase the ability to work with estate representatives, increase your marketing, and therefore increase your business and your income. Thanks for checking out my blog today. Kevin Sayles at probaterealestateSales101.com.